Hi, and welcome back to Focal Point AFR Talk. Brian Fisher is my name, talking here about anticipating the ruling from the Supreme Court tomorrow. Now, we may be surprised, and they may issue a ruling that's absolutely just fine. Anything short of upholding DOMA, anything short of upholding Prop 8 in California will be a setback for the rule of law. It'll be a setback for a constitutional form of government. It will be a setback. In fact, you can just eliminate the first three words of the Constitution. First three words of the Constitution, we the people. That will be utterly meaningless if the Supreme Court does not uphold Prop 8 and does not uphold DOMA, period. Anything short of that, the American people have been robbed of the capacity and the right and the authority to be a self-governing people. The people of California have already spoken. They have said, by 7 million of them going to the polls, we believe marriage ought to be the union of one man and one woman, and we want to elevate protection for marriage to our state constitution, the highest level of protection we can give it. So the people of California have spoken, 7 million of them. If the Supreme Court overturns Prop 8, they will have disenfranchised 7 million California voters. You know, the left is up in arms about this Voting Rights Act today, the fact that one section of it has been gutted. We'll talk about that in a few minutes. But they're all about voter suppression, and we've got to protect the voting rights of minorities, and we got to make sure that their vote is not suppressed in any way. Well, what about the Supreme Court suppressing the vote of 7 million Californians? If they overturn this, then that's exactly what they will have done. They will have disenfranchised 7 million Californians and say, we are not going to allow you to be a self-governing people in the state of California. If they overturn DOMA, again, they have made we the people absolutely meaningless, because the Constitution sets up a form of government where our elected representatives make laws. The people that we vote, the people that we choose, the people that we send to Washington, D.C., they're the ones that make the laws. And the responsibility of the executive branch is to implement those laws. And the responsibility of the Supreme Court is to enforce or apply those laws when there is a dispute between the states, when there is an issue of some kind of international crisis that needs to be dealt with. The Supreme Court was never imagined by the founders to be able to meddle with the internal affairs of a state. That wasn't its purpose. You know, if you got two states that have a border dispute, or they've got a dispute over water rights or something like that, well, somebody's got to decide that dispute. That was the role of the Supreme Court. But if it had to do with something within that particular state, the state has its own judicial system. Every state has its own Supreme Court. And whatever decision it makes regarding the internal policies of that state, that's it. That's as far up the ladder as things were designed to go. So just completely out of kilter, the fact that Prop 8 is even at the Supreme Court, that's already a defeat for the form of government that was given to us by the founders. The founders would be looking at this and saying, what in the world is this even doing in the Supreme Court? I mean, even before they look at whatever the Supreme Court decides, says, what are you guys doing? This is not the form of government that we created for you. This is not the way we set it up. What are you guys doing? Delegating all of this authority to the Supreme Court? We never gave the Supreme Court this kind of authority. So they would be just horrified to see what we have done to the frame of government that they had established. You know, so when it comes to DOMA, that was a law enacted by Congress. And by the way, don't let anybody fool you on this. Don't let anybody confuse you. People are going to talk all the time about how Supreme Court rulings are, quote, the law of the land. Absolutely, flatly wrong. Roe v. Wade is not the law of the land. It is not a law. It is a ruling issued by a court. A law is something that Congress passes. Has Congress ever passed Roe v. Wade? Has Congress ever passed a law saying you can kill a baby at any time, at any stage during pregnancy? No. Congress has never done that. In fact, they've done exactly the opposite. They've tried to pare back the damage that Roe v. Wade has done. So Roe v. Wade is not the law of the land. It is a misguided ruling by a Supreme Court that's been wrong in the past and can be wrong again. You don't think the Supreme Court can be wrong? I just give you two words, Dred Scott. So the Supreme Court obviously can be in error. They can make dreadfully wrong decisions, and they did in Roe v. Wade, and they might be about to do it when it comes to marriage. So the point here is that Congress passes laws, And if the Supreme Court were to impose same-sex marriage in all 50 states tomorrow, that would not be the law of the land. That would be a misguided, erroneous, horrible, egregious judicial expression of tyranny and judicial activism and legislating from the bench. That's what that would be. It would be a ruling and nothing more. And it would be as misguided a ruling as Dred Scott was. Now, when Congress enacted DOMA, that's a law. Both houses of Congress passed it, passed with overwhelming majorities. I think it was 342 to 67, something like that, when you combine the vote in the House and the Senate. It was signed into law by a Democratic president, Bill Clinton. That is the law of the land. That's the law. DOMA is the law. The Supreme Court this is the law established by our elected representatives. If we don't like DOMA, we can vote somebody else in. They can go in there and undo DOMA. They can repeal it. That's what Congress has the authority to do. But we don't vote for the people that are on the Supreme Court. We have no say. We have no influence over their appointment or over their decisions. They're not accountable to us in any way. So that's the whole point of having a constitutional form of government, where those that enact the laws that we have to live by, they have to face the voters. They've got to face the electorate. The Supreme Court does not have to do it. Whatever they do, as misguided as it is, they never have to face any accountability from the voters. Now, they can be impeached, but we don't have legislators right now that have the stomach to exercise that constitutional prerogative to keep them in line. But regardless, they have absolutely no direct accountability to the American people, where legislators do. They got to stand for re-election every 2 years or every 6 years. So what I'm suggesting here, if we use the legal thinking of Thomas Jefferson and James Madison — by the way, if you want to jump in on this conversation, 888-589-8840, 888-589-8840. Now, here's what I'm suggesting. Here's what I think Jefferson and let me put it this way. Here's what I think Jefferson and Madison would counsel us to do. I think what they would say to the states, the individual states, especially the ones that have marriage amendments. Remember, 30 states have actually amended their state constitutions to define and protect marriage as the union of one man and one woman. Jefferson and Madison would say to them, if the Supreme Court invalidates those constitutional amendments, just ignore them. They have no authority to do that. They have no right to do that. They've got no moral authority to do it. They have no ethical authority to do it. They have no legal authority to do it. They certainly, based on the 10th Amendment and the absence of marriage in the Constitution, they absolutely have no constitutional authority to do it. So just nullify it. Just ignore it. Just declare that ruling, not even a law, it's not a law, it's a ruling. Just declare that ruling, because it's unconstitutional, is null and void in our state. It has no legal effect in our state. In other words, we are going to continue to recognize as marriages only the unions of one man and one woman. We are simply not going to recognize any other marriages. We don't care what the Supreme Court has told us we have to do. We are bound by the Constitution, not by the Supreme Court. If the Supreme Court oversteps the Constitution, we don't have to listen to them. We're not bound to follow completely unconstitutional rulings where the Supreme Court steps outside the parameters that we, the people, have drawn around it. And Congress can do the same thing. Congress can convene, and they can say, we as Congress, we enacted DOMA. We think it's a fine law. We are going to ignore what the Supreme Court has said. We're going to ignore it. We're going to reject it. We are going to continue to recognize for federal purposes only the marriages between one man and one woman. Only spouses in those marriages will be eligible for federal benefits, and that's up to us. Supreme Court has no say over spousal benefits and over pay for federal employees. That's our province. We get to decide that. We get to decide who's eligible. We get to decide what those benefits are. Now, let me ask you this. If the states were to do it, the 30 states that have marriage amendments say, fine, Supreme Court's issued his ruling. We're going to ignore it. They have exceeded their authority. We have no obligation. In fact, if we recognize their ruling, we give credence to it, then we are violating the Constitution, because the Constitution gives them no authority to do that to us. So we have compounded their unconstitutional act by an unconstitutional act of our own. So if state legislatures, and hear what I'm saying, this has to be the act of state legislators. I'm not talking here about some kind of revolution. I'm not talking about rebellion. I'm not talking about riots in the streets. I'm talking about state legislatures, the people who have been elected by the people in those states convening in legislature assembled and voting to reject the Supreme Court ruling. That would not be rebellion. That would not be revolution. That would be a demonstration of what a constitutional form, what a constitutional republic looks like, what a representational form of government looks like. And Congress would do the same thing. Congress would meet. Congress would say, we're fine with DOMA. We reject the unconstitutional ruling by the Supreme Court. Again, that's not a revolution. That's not a rebellion. That's how a constitutional republic, that's how a representative form of government is designed to work. So both the states and Congress could just refuse to recognize the legitimacy of any Supreme Court action that overturns the Defense of Marriage Act. Deciding the definition of marriage for federal purposes is the responsibility of Congress, not the Supreme Court. And Congress should not surrender its constitutional authority to the Supreme Court. Now, let me ask you this. If Congress does this, if the states do it, what can the Supreme Court do? What can the Supreme Court do about it? Nothing. They have no police force they can call. They have no capacity, no power to enforce any of their rulings. And what a lot of people don't understand is right now the authority that the Supreme Court has is purely a moral authority. You know, you break a law, the governor of your state can send the police after you. The Supreme Court can't do that. They don't have anybody they can order to go arrest you or detain you or put you on trial or anything of the sort. They've got no police power. So if their ruling is simply ignored, there's absolutely nothing they can do about it. And if it's the representatives of the people, the elected representatives of the people who do this, they assemble together, they vote, they represent the will of the people whom they were elected to represent, and they decide to reject an unconstitutional ruling from the Supreme Court, there's not a single solitary thing the Supreme Court can do about it. And I think what the Supreme Court fails to recognize is they owe everything to the goodwill of the American people. We have capitulated. We have cravenly capitulated. We have surrendered after they have issued one unconstitutional ruling after another on prayer, Bible reading, 10 Commandments. At some point, the American people, through their representatives, have to rise up and say, that is it.